subscribe the channel and hit the bell to not miss any update. Part 2 Citizenship from Article 5 to Article 11. Part 2 of the Constitution simply describes classes of persons who can be the citizen of India at the commencement of the Constitution. Our Constitution leaves the entire law of citizenship to be regulated by law made by the Parliament. Article 5 states citizenship at the commencement of the Constitution. Article 5 says that a person who has his domicile in India and also fulfills any one of the three conditions, that is, if he was born in India or if either of his parents was born in India, or if he has been resident in India for 5 years before the commencement of the Constitution, become a citizen of India by domicile at the commencement of this Constitution. The domicile of a person is that country in which he either has or is deemed by law to have his permanent house. Two elements are necessary for the existence of domicile. Firstly, a residence, though need not be continuous, but it must be indefinite. Secondly, an intention to reside forever in the country. Some of the case laws for this article. First case law is between Pradeep Jain versus Union of India. In this case, Supreme Court has held that in India, Article 5 recognizes only one domicile, namely domicile of India. It does not recognize the notion of state domicile, that is, different domicile for different states of India. Second case is Sharafat versus State of UP. In this case, courts said that the domicile of an infant generally follows the domicile of his father. It means that a newborn child will have the domicile of his father. Next case is Karimunisa versus State of MP. Court held that a married woman takes the domicile of her husband. In Prakash versus Sahini, court said a widow retains the domicile of her husband until changed it by her own act. Article 6 is about rights of citizenship of certain persons who have migrated to India from Pakistan. This article says that a person who has come to India from Pakistan become an Indian citizen if he was born in undivided India, or either of his parents or any of his grandparents was born in undivided India. Apart from this, he also needs to fulfill any one of the two conditions. Either he has migrated to India before 19th of July 1948 and started residing in India, or in case he migrated to India on or after 19th of July 1948 and made an application for registration in the prescribed form and in the prescribed manner to the officer appointed for registration of migrated person by the Government of India, and he has been registered by the officer as citizen of India. But a person could be registered in this way only if he has been resident in India for at least 6 months before the date of his application for registration. 19th of July 1948 is the date from which the permit system for such migration was introduced. Article 7 is about rights of citizenship of certain migrants to Pakistan. The first paragraph of Article 7 says a person who after 1st of March 1947 migrated to the territory of Pakistan from India cannot be regarded as the citizen of India. But in the proviso para or the second para, it is said that a person who migrated to Pakistan from India after 1st of March 1947 but later returned to India under a permit for resettlement or permanent return issued under the authority of any law could become an Indian citizen. Moreover, it is stated that every such person shall deem to have migrated to India after 19th of July 1948 for the purposes of Clause B of Article 6. Article 8 is about overseas citizenship. Article 8 states rights of citizenship of certain persons of Indian origin residing outside India. It says that a person who was born in undivided India or any of whose parents or grandparents was born in undivided India but he is residing outside India shall become an Indian citizen if he has been registered as a citizen of India by the diplomatic or consular representative of India in the country where he is residing. It can be before or after the commencement of the Constitution. Thus, this provision covers the overseas Indians who may want to acquire Indian citizenship. Article 9. Persons voluntarily acquiring citizenship of a foreign state not to be citizens. If a person voluntarily acquires the citizenship of any foreign state, then he cannot claim Indian citizenship under Articles 5, 6, and 8. Article 10 says about continuance of the rights of citizenship. This article provides that every person who is or deemed to be a citizen of India under Articles 5, 6, 7, and 8 can continue to be a citizen of India, but his citizenship will be dependent upon any law made by Parliament. It means that Parliament has the power to take away the right of citizenship from any citizen of India, but citizenship can be taken away only by a law expressly made by Parliament. Article 11 says Parliament to regulate the right of citizenship by law. In this article, it is said that Parliament can make any provision for the acquisition and termination of citizenship and all other matters related to citizenship. Thank you so much for giving me a valuable time. Do thumbs up if you like the video and do let me know in the comments if you have any doubts, and I'll try in the best possible way to clear those doubts. Do subscribe the channel and hit the bell as I'll be posting regularly such law content. Till then, I'm Ricky signing off.